Okay, so next we're going to move on to talking about conflicts of interest. And so predominantly today, I'm going to be talking about how to avoid how when board members have a conflict of interest, how to identify that, how to disclose that, and how to recuse yourself. Conflict of interest has two different categories, the Form 700, which Nicole is going to go over in more detail today. And Nicole, you can move on to the next slide, sorry. We can move on to the next slide. Thanks. So typically when we think about generally conflicts of interest, we think about ethics. And so there's common ethics, which is more, I think a lot of people think about personal ethics or religious ethics or moral ethics, and versus what I think we're going to get into more today is legal ethics. And so we'll go over conflicts and incompatibilities. We're going to go over perks and benefits and how that can possibly trigger a conflict. And we're going to go over fair procedures today. So that's a little overview of what I'm going to touch upon. And so moral ethics versus legal ethics. Moral ethics is more values and, morality and good and evil and right and wrong and virtue and vice. And you do want to carry that with you throughout your decision-making process. But legal ethics is a little bit different. And so you'll want to understand that as well, because sometimes it won't exactly surface in your morality gauge. That legal ethics is really an attempt to assure that assure the public that the public's business is being conducted in an ethical manner. And we can move on. And so guiding principles of conflict of interest laws attempt to prevent honest government agents from succumbing to temptation by making it illegal for them to enter into relationships which are fraught with temptation. And it's not just the actual improprieties which the conflict of interest law seeks to forestall, but it's also the appearance of propriety. So this area of law is concerned with the appearance of something that's a conflict of interest, as well as an actual conflict of interest, because the goal is to preserve and uphold the institutions of government. And we want the public to have trust in public governance and public decision-making. You can move on. And move on again and again. So I'm going over the Political Reform Act. And so Nicole has a separate presentation on the Form 700, which likely all of you are required to fill out. And I'll go over it briefly. And mainly what I'm going to be going over today is when you need to disqualify yourself from making a public decision. So the Political Reform Act has some parameters on when you cannot participate in a legislative body decision because of a personal relationship or a financial conflict of interest, which we'll go over. Next slide. So the Fair Political Practices Commission is the governing body that investigates all violations of the Political Reform Act, and it imposes penalties when appropriate. And they provide written and oral advice to public agencies and officials. So what I'm talking to you about today, I'm going to give you an overview. But if you actually had one of these conflicts come up, or if you weren't specifically able to tell whether you had a conflict, you would need to contact the FPPC, and they will give you verbal and written advice when requested. And so they're going to help you decide whether you actually have a real conflict or not. I can assist you in, I'll obviously recommend that you reach out to the FPPC if you do have something that is in a gray area. Oftentimes things are pretty clear and, we can assist you, but you can never rely upon my advice as your district counsel. If you are challenged on any of these subject matters that we're going to talk about today, you can only rely upon in a court of law the written advice from the FPPC on a particular situation at hand. And that does give you immunity from criminal and civil prosecutions. The FPPC does have a website, and they have a call-in number, and they're available every day throughout the week. And they will be available to take your calls, and they'll let you know if you should submit a request for written advice or not. You can move on. And so we're going to go over who has to file a Form 700, and Nicole again is going to go over this in more detail. There's Government Code 87200 filers, and those are not special district boards. These are going to be your Board of Supervisors and county officials, like County Council is a statutory filer, the County Treasurer, the District Attorney, and so forth, and certain consultants that deal with retirement accounts. And the certain employees would be County Council, and but the district boards, you guys are designated employees, meaning you're designated in the county's local conflict of interest code, which the county puts together, and it's embedded in the local code here in Siskiyou County. And that's a requirement by law that the county adopts a conflict of interest code. And the clerk's office reaches out to each district on a biannual basis and asks which employees should be designated on there. The board members are always put on the code because you are the decision makers. And also candidates for office have to fill out a Form 700. We can move on. And so what do you disclose on the Form 700? And Nicole will go over this in more detail. And in your Form 700 instructions, it's going to go over different types of investments that you need to disclose, interest in real property except for your personal residence, and sources of income, gifts and loans and payments, and certain business interests and positions in those businesses. Those are typical categories of what is going to be disclosed. And the instructions in the 700 form give much more detail, because whether you have to disclose any of those items is going to depend. And so we're not going to go over it. I'm not going to go over it in detail, but the clerk and the FPPC are available for detailed questions as you're going through that form. We can move on. So this is the main topic that I'm going to talk to you about today, which is, when do you have to disqualify yourself at a board meeting for an item that's on the agenda that the board is going to be making a decision about? And so the main rule is a public official shall not make, participate in making, or in any way attempt to use his or her official position to influence a government decision in which he or she knows or has a reason to know that he or she has a disqualifying financial interest. We can move on. A public official has a disqualifying financial interest if the governmental decision will have a reasonably foreseeable material financial effect. This is distinguishable from the effect on the public generally. And that means that if you make a decision where, and this I'm going to use an example that might be more clear because each one of you has different jurisdictional areas of decision making. But a strong example would be the Planning Commission tends to make a lot of decisions that could make real estate or real property more valuable. But if that decision positively financially impacts the general public generally, and the decision makers are part of that general public, and the effect is the same on the decision makers as it is the public, then that would be an example of, it affects everyone. So therefore, there's not a conflict. And so those types of situations are not disqualifying. But if it has a specific impact on the official or his or her immediate family, or any of the official's financial interests in which you disclose in your Form 700, that's going to be the area where you're going to be disqualified and want to step away from that decision and recuse yourself. We can move on. So these are examples of financial interests. So if you own some local businesses and your decision has a direct you have an indirect investment of at least $2,000 in a local business, or if you hold a management position in a local business that is going to have a financial interest in a decision that you're making, then you're going to need to disclose and recuse yourself on that. If you own real property or have a lease where your decision is going to have an impact on that, that's another category. And direct or indirect interest worth at least $2,000. And sources of income. So perhaps you receive income from a business or certain transactions out in the community, and your decision is somehow going to impact that source of income. If it has a positive impact of over $500 in a 12-month period, that's going to be a financial interest that triggers this. And then if there's any kind of gift that you've received or an immediate family member has received that is possibly intertwined with a decision or is influencing a decision, again, that could be, for example, a local business is seeking a contract, and your spouse received a gift over $500 from that local business owner, and now you're seated making a decision on whether your district should contract with that business. That would be the type of situation how a gift could come up and impact or seek to influence your decision. And so you would want to disclose and recuse yourself in that type of situation. Okay, we can move on. So this is a 4-step test to assist you in trying to figure out whether there's a financial impact to yourself in a decision. And so I'll go over each one of these steps in a little bit more detail, but this is an overview of it. And step 1 is the financial effect of your decision reasonably foreseeable? Is it material? Is the effect of the official, is the effect on the official the same as on the public generally, as I discussed before? So if you make a decision and it has a positive financial effect on you, but it has the same positive financial effect on the public generally, that's probably going to be okay. And when is the official participating in making, or using his or her position to influence the governmental decision from when the financial effects results? And so I'm going to go over all those right now. And so Nicole, you can move on. So step one, what's reasonably foreseeable? So is it the subject matter of a governmental decision? So if it's on the agenda and you can see that it's going to impact your personal finances, then that's presumed to be reasonably foreseeable, and you need to disclose and recuse yourself and step away from that decision. That means if the financial effect can be recognized as a realistic possibility, that's what reasonably foreseeable means. So you're on notice that the item on the agenda is something that's for you to make a decision on, and you reasonably should recognize that if you make that decision, you're going to have a positive financial impact, to you personally, not just to the general public. Then that is the type of decision that you need to step away from. What's not reasonably foreseeable, if it's just really far-fetched and hypothetical or theoretical, and you have to put together like some really crazy far-fetched scenario to get to that financial benefit, that might be a stretch, and so it might not be reasonably foreseeable. So that's something where the financial effect can't be expected absent really extraordinary circumstances that's not really subject to your control. And so it's hard to describe what that is, but the best that I can describe that it's going to be some extraordinary far-fetched scenario, and you can call me if there is such a scenario and you want to discuss whether it's reasonably foreseeable or not. You can call my office and we can discuss that in more detail. But it's basically, it's almost likely to never not happen or ever come up. That's a good way of thinking about that one. We can move on. So material. Material means how much of a financial impact is it? And so it's best to think of material as what's not material. That's a little bit easier to think about. And it's not material if the financial impact is nominal, inconsequential, or insignificant. And so really what that means is that's like just a few dollars or almost nothing. But anything above that, that's going to be material. We can move on. And then the public generally, this one I have talked about a few times now. It's where the government's decision does create a financial effect on a public official's financial interest, but it's indistinguishable from its effect on the general public. And so that's the type of decision that you can participate in still. And it means, let's say, for example, a district decides to reduce their rates. And so that would have a positive impact not only on the district board members, because you would be paying less per month for whatever utility that you govern, but it would also have the same effect on all of your constituents. So that might be a good example of why the effect on your financial interest is not unique compared to the effect on the general public. Okay. And so what is a decision? So that's participating in making, or influencing the decision in some way. So making a decision is when you vote on something, when you appoint members to a committee or a subcommittee or an advisory committee that advises your legislative body, obligating or committing an agency to any course of action, or entering into a contract. Those are all examples of making decisions that you would want to keep in mind. Does that decision have a financial impact on you? Participating in making is a little bit different. So that can be, just having a discussion and providing information on a topic, which could influence a decision, providing an opinion or a recommendation about a subject matter that could lead to a decision, or negotiating or advising on a decision or a contract. Those are all ways that you may not necessarily be making a decision, but you're participating in making a future decision or influencing. And influencing, and this is for the purpose of affecting a decision. So you could make an appearance at an event on behalf of an agency that could possibly curry favor, or you could be making contacts with staff members that could influence other board members, because you know that you would have to recuse yourself on that decision, but you still go ahead and talk to staff about it, and then staff talks to the other board members. Those could be ways that you could get into trouble, and still, even though at a meeting you would recuse yourself, behind the scenes, you're actually influencing the decision and making other board members aware or staff aware of your position on that. And so you don't want to do that either. Okay. Sometimes you might have to participate in a decision that could financially impact, because the decision is crucial to be made. And for example, let's say the board is down to just a quorum, and let's say everyone is conflicted on this decision on the board, but the board still has to make the decision. And you wouldn't be required to participate for a reason of a tie, because you can just reschedule a meeting until other board members get there. So you can't do it for a reason of convenience. If the meeting can be put off without your participation, then that needs to happen. But if the meeting cannot be put off and the decision has to be made, you may have to participate. And so this is very rare, but you're only allowed to participate when no reasonable alternative is available. And that's going to be a really rare circumstance, like you're approving the district's budget and there's an item in there that you may or may not have some interest. We can move on to the next screen. And so in that situation, let's say you're adopting the entire budget and there's one decision that maybe, impacts a piece of property or a spouse or what have you, or a business relation. You can try to segment so that you are carved out of that one decision, even though it's part of like a general plan or a budgetary decision. And so you want to try to evaluate whether the decision that's creating the conflict can be segmented from other decisions, and so that the public official can participate in all the other decisions that make up that larger budgetary decision. So this is, but sometimes, things can't be disarticulated. And so if that comes up, again, this is very rare when this comes up. And so I would advise that you call our office to seek advice. And I may recommend that you call the FPPC and get a oral or written decision so that you can go ahead and move forward and make that decision and have immunity on that. And so that would be the way to resolve that situation. If this does come up where there's no other way and that you have to participate, you're going to want to get the thumbs up from the FPPC on that. And so we'll move to the next slide. When you're not in the forced situation where you have to participate in the decision and you've received the FPPC's approval, typically in a regular situation where you do have a conflict of interest, you recuse yourself. It's very easy. You disclose what the disqualifying conflict of interest is. You recuse yourself from making that decision and you leave the room. And that's how you deal with that. And you let the rest of your board make that decision. If you recusing yourself from the decision and leaving the room makes it so you don't have the ability to make the decision, then you would just put that on the next agenda and hope that you have additional board members to make that decision and move on. Okay. So there are penalties to violation of the Political Reform Act, and those can be in the way of an administrative fine, a civil fine, criminal penalties, or possibly the inability to run for office. Again, the FPPC is the body that's going to take action on all of that, but you don't want to violate the Political Reform Act because it could remove your ability to run for public office ever again, and or you could be prosecuted criminally or civilly and have some pretty hefty administrative fines. So you want to be really careful about this because getting in trouble for conflict of interest, or I think we can all use the lamest term, corruption, that is something that we want to stay away from. And so if you do ever have any concerns about a decision and whether you do have a material financial interest in any one of your decisions, that's when you call the FPPC hotline on their website and you talk to them directly, because again, county council can assist you in going through the analysis of all this, but you cannot rely upon county council's advice. You have to rely upon the FPPC's advice to receive your get out of jail free card, so to speak. And so the FPPC is the only body that can, give you immunity on a decision that's possibly a conflict. And we can move on to the next slide. There's different types of conflicts of interest. And so that was the Political Reform Act. Now we're going to talk about Government Code Section 1090. Government Code Section 1090, you can get in trouble with, and this is only dealing with contracts. So Government Code 1090 prevents an officer or an employee, so this can be anyone in your district organization, they may not participate in the making of a contract in their official capacity if they are financially interested. And here's where you can get your other board members in trouble. If you are interested in a contract, meaning you have some kind of financial interest, or your spouse or a business partner has a financial interest in a contract that you're making, it could be, a son or daughter, you cannot enter into that contract. And if you can't recuse yourself on this one, because if the board goes ahead and enters into that contract, the entire contract is going to be void. And so the board cannot make a contract in which one of its members is financially interested. So this is a situation where it's not that you can't just recuse yourself. The entire board can't go forward with the contract if you or a family member or a business partner are financially interested in that contract. Move forward. Next slide. We can move to the next, thanks. So the elements of Government Code 1090 are that there's a public official that has a financial interest or participates in a contract, and this includes purchasing items. The kicker is the contract has to be entered into or finalized for there to actually be a violation. So you can get right up to the negotiating point, and then all of a sudden realize, oh my gosh, if I make this purchase or if I enter into this contract, or if our board follows through with this transaction, it's going to have a positive financial impact on me, my family, or my business partners. The entire contract is going to be void, and this is going to get everyone in trouble. But the contract has to be entered into, i.e. both parties have to sign, or the transaction has to be finalized. So you can stop it before it happens. And so that's the one saving grace on Government Code 1090 conflicts of interest, is that you can stop it even though the ball is rolling, so to speak. Negotiations are, underway. If you realize it, just, it can stop by not entering into the contract. Next slide. So there's an exception to having a financial interest in a contract, and there's a very lengthy long list of remote interest exceptions. And I would encourage you to Google and look up Government Code 1091. But those are going to, so an example of that is, say you're on the board of directors of a nonprofit and you don't get paid, and the board that you're seated on is going to enter into a contract with that nonprofit. That might be something that would qualify as an exception or a remote interest under 1090. You still want to disqualify yourself from that decision. And I would encourage you to call my office and talk to me about that, because Government Code Section 1091 is very complicated and nuanced. And so we would go over and analyze whether you do have some type of remote interest exception, and we would assist you with that. But in general, Government Code 1090 is a big deal, and there are consequences, which we'll go over next, and we'll move to the next slide. So the penalties are, the contract is void. So that means the vendor or the contractor that the board has engaged with, they could fully perform the contract. Say it's, building, a new water facility, and then it's discovered that, you had an interest in that contract. That contractor is not going to get paid. Okay. It's going to be void, and there's no legal recourse there. You're going to have to and if the contractor has been paid and it's discovered, the contractor is going to have to give all the money back, and the public official, any financial interest that the public official received, they'll have to disgorge all those monies as well. There's a permanent bar from holding office if you get in trouble for this. So you'll never be able to hold public office again. It's a criminal misdemeanor. And there are also additional civil or administrative penalties that you'll be subject to. So Government Code 1090 is extremely harsh, and there are very serious consequences to this. And so if you have any questions or concerns about your legislative body entering into a contract where you could have some type of financial interest, whether it's you, spouse, family, business associate, you really do want to contact my office before the legislative body enters into that contract, because the consequences could be dire. Next slide. So the FPPC also provides written advice to questions on Government Code 1090. And so our office can assist with that. And the requested advice is forwarded to the Attorney General and the local district attorney so that everyone is aware that there is a possible issue. And that's for transparency reasons, and that's to encourage the public officials and agencies to do the right thing and be aware of how dire the consequences are. Next slide. This is the third area of conflict of interest that I'm going to talk to you guys about today. And this is just the common law doctrine of conflict of interest. And this is where this is found in case law. And so there's numerous state court and Superior Court cases that go over the common law doctrine of conflict of interest, but a public officer is impliedly bound to exercise the powers conferred upon him with disinterested skill, zeal, and diligence, and primarily for the benefit of the public. And so here, this is where you might get in trouble for having a conflict of interest where you don't have a financial interest, but maybe you're making decisions that benefit your best friend or your neighbor. This is where the common law doctrine will catch and clean up those types of decisions, because the other two areas of law that we already discussed, they limit to spouse or direct family members or business associates, where this can catch a decision where you're trying to be helpful and provide a decision that might be really beneficial to your neighbor or a friend. And so the common law doctrine of conflict of interest could expose you to consequences for those types of decisions. Next slide. Next, I'm going to talk about incompatible offices. This is Government Code 1099. So it is okay to hold board seats on multiple public agencies, so long as those simultaneous public offices don't conflict or have overlapping functions. And so an example of this could be you are seated as a board member on a community services district, and also within that same jurisdiction, there's a separate fire protection district. And so you're seated as a member on both of those boards, and the community services district sells water to the fire protection district. And so they are customers. And so one board is making decisions or impacts another board. That can be an example of where there's overlapping functions. This is rare, but we have had circumstances in Siskiyou County where this has come up. And when it does come up, you would want to step down from the most recent board that you've held, and if you don't step down, then a lawsuit could be filed to force you to step down. And so it's good to be aware that holding multiple public offices, if you have overlapping functions or jurisdictions or decisions that impact, the other agency, you don't want to hold seats on both of those boards. Okay, and we're ready to move on. So I know this is a complicated area of the law, but there's multiple resources, as I've explained, that are available to you. The FPPC is going to be your biggest resource, because that is the agency that can give you immunity from any perceived or suspected conflict of interest in any of these areas, except for the common law area. But the FPPC does advise on the 1090 violations and on any conflict of interest with regards to financial interest in decisions. And so if you ever have any questions or concerns about a decision that you're about to make, you can reach out to our office or just independently the FPPC office. Our office will obviously advise you to contact the FPPC, and depending upon the seriousness of the possible decision, you may want to ask for written advice so that you do have immunity in a court of law. And so I'm going to open it up to questions now.
Does anybody have any questions for Dana? Okay, Dana, I'm not seeing any hands, so.
Okay, well, thank you all for allowing me to share and provide you information. And please take note of the FPPC website for future reference in case you do have any questions or concerns about any of the decisions you're making, and their telephone number is on that website. And thank you for serving on your district boards, and we appreciate your public service.